Yes, welcome to our Zoom where we're going to talk about security deposits, bankruptcies. I think that's it, right?
Yeah, exactly.
All right. So, main reason we're having this, we're getting a lot of questions about both those topics. So, we thought we would do this. It's always easier. Danielle, do you want to record this so we have it in case anybody who can't be here wants it later?
Yes, the recording is in progress. Thank you.
Awesome. Thank you. All right. I'm going to let Paul start with Philadelphia. If you're not from Philly, I apologize. We'll move on to other areas. But for right now, we're going to start with Philadelphia and security deposits because that's one of our hotter topics.
Yeah, we'll start with that. And then anyone that's just from Philadelphia and doesn't care about bankruptcy laws could then just jump off the call.
But don't, because you need to hear about the bankruptcy laws. Nice check.
Okay. All right. So Philadelphia passed a new law recently. Guess it was about 3 months ago, that basically said that for any security deposits that you take in excess of 1 month's rent, the additional amount the tenant has the option of paying over a 3-month period. So if, for instance, your rent is $1,800 a month and you want to charge $3,600 in security, which would be 2 months' rent, you can collect 1 month or $1,800 up front. The other $1,800, the tenant has the option of paying over a 3-month period at $600 a month. So if you lease the property in December and you collected the 1 month's rent in December upfront for security, for the months of January, February, and March, you can charge them $600 a month additional rent or additional security deposit over and above the rent. The problem, this is what everybody asks me, is what happens when the tenant doesn't pay the security deposit? Basically, trying to not use bad language.
You're SOL.
Yeah, thank you.
How's that?
Yeah.
Just go over next to each other.
Yeah, you always use the help.
Yeah.
Yeah, the problem is that you would have to file an eviction case or start an eviction case in Philadelphia. And for those of you that do this type of work in Philadelphia, know you first have to start with diversion. And it takes about 4 to 6 months to get an eviction to go through in Philadelphia. So the reality of collecting that money is slim to none. So Janelle said, you're basically SOL.
And the main reason behind that is, as we all know, you can only collect 2 months of a security for the first year of the lease. And after the first year, you have to give 1 month back. So the problem is when they don't pay it over the 3 months, and then you start the eviction process, by the time you're done, you got to give it back anyway. So what's the point?
Exactly.
We got a chat going on here. See, this is why I need my own computer. I usually monitor the chat. Oh, no. There we go. Can we require the funds to be certified, Paul?
No, you cannot.
Does the new law apply only to the city of Philadelphia?
Yes, this is just for the city of Philadelphia, and it does not apply to commercial leases, or if you're renting to a commercial tenant, even though it's residential in the sense that they're putting in a individual in that property, you can still collect the additional money up front. Keep in mind also that the tenant can pay you up front. They don't have to pay over 3 months. I don't know who wouldn't if they have the option. I can tell you that most large landlords have decided to only collect 1 month's rent or less and to not have to deal with the situation, but that's totally up to you. Right? If the tenant can't afford to pay the 2 months up front, do you really want to deal with a situation where the tenant's now paying the additional 1/3 of the security deposit every month for 3 months? Are they really going to be able to afford that? I don't know. But that's a business decision that you guys will have to make on an individual basis. The law goes into effect, or went into effect actually on December the 2nd. So as of now, as of December the 2nd, you have to start complying with this law. So you're basically giving the tenant the option of either paying it up front or paying it over 3 months rent.
And that's what someone asked. Do they have to offer it or only if they request it?
No, you have to offer it. Okay.
Right.
And we sent everyone an addendum that I prepared NAA, I put it also in the NAA lease so that if you're using the NAA lease, there is a addendum form as part of the lease package.
And if you're not using NAA and you don't have it, just reach out to April and she can get it to you. All right, we got two more questions. Are application fees required to be $20 each now?
$50. So you don't have to charge 20. It's a maximum of $50 or the amount that it's actually costing you.
Okay, great. As a landlord, do we have to retroactively any deposits paid over the 1 month? Well, you're going to have to do it at the 1 year mark anyway. So if they've already paid you the 2 months up front, you don't have to give anything back now, but you would at the 1 year
Yeah,
anniversary.
and it goes by the date of move-in. So if they've signed a lease agreement and have already moved in, you're okay. If they moved in prior to December the 2nd, they moved in past December the 2nd, then yes, they'd be entitled to pay over 3 months.
Okay. What about security deposit insurance? I'm not even going to go there on this call. I don't know if you want to go there on this call, but I am not a fan of this security deposit insurance, these companies. I've had this conversation with a couple of clients recently. I think these are a way for these companies to get around security deposit laws. And while there's nothing on the books right now that say they're illegal, I think that you're asking for a lot of trouble here.
Yeah, and I can tell you when we negotiated the language that went into this bill, that was one of the issues that did come up. And the legislators decided not to tackle that issue in this bill. So it's not really addressed. If you do have that insurance, then that's okay. It's not covered by this bill, so it doesn't apply to it.
But that's a conversation we can have down the road if somebody wants to reach out to us individually, so we can tell you all the reasons why we hate it. All right. Two questions. Any lease updates to consider deposit as rent? I don't know what they mean by that.
So the last month's rent in advance, which is what I assume that this question is addressing, is considered a security deposit. You can call it whatever you want to call it. If you're taking money in advance, that is security deposit. If you take 3 months rent in advance, 2 of those months are going to be considered a security deposit.
It doesn't matter what you call it. That's why I don't like the insurance. Well, that's one of the reasons why. Any applicant disclosures? Well, that's what Paul was saying. You do have to let them know they have this option.
Exactly.
Okay. Is admin fees included in app fees? I don't know what you mean by an administrative fee.
So I've gotten this question in the past. An admin fee is a fee that you're adding on to the rent. I hate to use the word that it could possibly, but I guess we'll go there. Could be possibly considered a junk fee. Those admin fees, why isn't that really rent? But no, that's not part of the security deposit. So that
No, they're asking about the application fee. So my guess is the admin fee is something they charge at the outset.
Okay, so the admin fee is separate from the application fee. It doesn't apply. So the application fee, you can take up to $50. If you have a separate admin fee, then you can collect that separately from the application fee.
Just be careful.
Yeah, just be careful with admin fees. I'd much rather see you call that rent, but I understand the reasons why you don't want to do that. Business decision.
So if it's termed as last month's rent, we need to give it back the last month of the first year. Is that correct? And yeah, yes, after the.
So just be advised that there's really no advantage anymore to calling it last month's rent. In the past, before the law changed, landlords were taking the first month's rent, 2 months in security, and a third month in the last month's rent in advance. Okay. Now, since the last month's rent in advance is considered a security deposit, there was a Supreme Court decision that came out about 4 years ago, Supreme Court of Pennsylvania, that held that last month's rent in advance is security. There's no advantage now to calling it last month's rent. You might as well just call it security. And I wouldn't apply it to the last month of the lease. I would apply it to the first month of the renewal.
Right, that was the next thing I was going to say.
You don't really want to give them the money back. You want to apply it to the first month of the renewal.
And that was their next question. Can they credit it? Yes, you can credit it.
So there's actually an advantage to calling it security and not the last month's rent in advance, because you call it the last month in advance, you're applying it to the 12th month, as opposed to if you call it security, you can apply it to the
13th month, so to speak.
13th or first month of the next year.
Does it need to go into an escrow and get interest? Yes.
Absolutely.
Anything you take in advance has to go in escrow account. And escrow accounts have to be an interest-bearing escrow account. You are allowed to take a 1% administrative fee out of that interest. For years and years and years, that wasn't, the interest rates weren't above 1%. They are now. So be careful of that.
And for the first 2 years of the lease, there's no interest on the security. The interest starts being earned after the second year. On the third anniversary of the lease agreement, you owe them 1 year's worth of interest, less the 1% fee
Admin
that
fee.
Janelle just mentioned.
If residents have stayed over a year and there's a last month's rent on file at this time, we should, all right, we already answered that. Can we collect a reservation fee during the application process and once approved, transfer it to security deposit? Yeah, I don't see why not. As long as it's
Yes.
not exceeding 1 month. Well, 2 months, I guess, so to speak, but you have to give them the
Yeah,
options.
that's fine.
Yada, yada,
It's
yada.
separate. That's a reservation fee. That's fine.
Meaning any update, unpaid deposits can be considered rent. Do you have applicant disclosure documents or recommendations? Unpaid deposits. Oh, you mean if they're going to pay over the 3 months, Dana? Yeah, okay. Well, that's what you're saying. There's an addendum. Is the addendum just a disclosure or is it outlining the? That's what Paul was saying. We have an addendum saying, giving them that option to pay it over the 3 months and how they need to pay it. So Dana, just shoot April an email and she'll send you that. Well, you use Blue Moon, right? Yeah, no, okay. So then just send April an email and she'll send you the addendum that Paul put together.
Or call me, Dan, and we'll go over it.
Okay. The nice thing is Dana's on our first screen here, so I can see her. Can you repeat the interest earned on the security deposit info? Yes. After 2 years, you have to pay interest on the security deposit
For the third year.
for the third year. You're allowed to keep a 1% administrative fee out of that interest, and that needs to be paid yearly on the anniversary. You can credit it to the account. You don't have to cut a check.
And nobody knows what the rate of interest should be. Nobody's able to figure that out. So if you think about it, if you put it into an interest-bearing account, that account earns interest. You know, some banks do it on a daily basis. So how would you ever be able to figure out what the actual interest is that the tenant earned, especially since you're going to combine all the security deposits into one account? So
Can we keep the reservation fee if the applicant cancels, whatever they signed? It all depends on what you've outlined in your contract. Are we the same as New Jersey? No, no. New Jersey, you can take a month and a half. Can't take 2 months in New Jersey. So New Jersey's a month and a half. Interest has to be paid out immediately, not after 2 years.
each year.
Each year at the anniversary of the lease agreement in New Jersey. So no, not the same as New Jersey. Okay. Other questions?
And I didn't finish the interest
Sorry.
that most landlords end up paying is like 1% interest is a reasonable amount. So if you think about that, would actually be a 2% interest rate because you're taking 1% in administrative fee. And I have never in my 40 some years of doing this ever seen a case where somebody brought it to recover for the interest that they were entitled to.
Usually it's thrown in because they're suing you about something else. That's the only time I've ever seen it.
Yeah, but then nobody's filing suit just over that couple of pennies.
To take a property off the market, we require security deposit. Now do we consider 1 month to take it off the market as 1 month's rent instead? It doesn't matter. You collect whatever you collect to take it off the market.
Yeah, what I would do in that case is if you're taking a security deposit of 1 month to take it off the market, also ask for the first month's rent up front. So that's how you would get the 2 months if that's what you're looking for.
Oh, that's a good point. Any rules for holding deposit that converts to a security deposit and whether it needs to be refundable? No. I mean, a security deposit's a security deposit. If they've signed the lease agreement, then, and they don't move in, then the lease is breached. And if you don't re-rent it, they're responsible for the length of the lease. And you can take that out of the security deposit.
Well, I think what that question is saying, and it's a little confusing, but if the property is taking a holding deposit, meaning a deposit to hold the property open, can you then convert that to the security deposit? And the answer is yes, you can go ahead and do that.
Okay.
That was a little confusing.
Yeah. Okay. Good. 1% that we have to credit the resident every year after the second year, only for Philadelphia. That's the
No.
whole state of Pennsylvania.
That's Pennsylvania law.
You can collect 1 month's rent, 1 month's security, and an administrative fee of any amount. You can't hold an administrative fee as a security deposit.
No, but the administrative fee is a separate fee, and I assume the administrative fee is for them to get internet and use the
Clubhouse.
tools, all that
I don't think so.
stuff.
They're calling it an administrative fee, a one-time fee.
It's a yearly thing.
Or whatever.
Yearly.
If you're paying it
Assume.
yearly, yes. If it's just a one-time fee and you're trying to charge that to get around the $50 limit on application fees, then no, you can't do that. If you're charging it and it's for what Paul's saying, that's an amenity fee, so to speak, and they're paying it as an amenity fee, then that's fine. Okay, so yeah, Jess, you feel free to jump in wherever you want, but you might be really tripled up in the room. One of the other things that we're seeing in court that Jess wanted me to talk about is what happens at the end of the lease term, okay? With the security deposit when they vacate. So at the point they surrender possession and you accept possession of the premises. So when they hand you the keys or they leave the keys in the apartment, you say, okay, thanks. Okay, from that point, your clock starts ticking. You have 30 days from that point to either return the security deposit or to send a security deposit disposition explaining why they are not getting their security deposit back. If you do not do that within the 30 days, okay, then you're going to be responsible for double the security deposit when we get to court. And in Philadelphia, especially, and this is for anywhere in Pennsylvania, but in Philadelphia, especially, I'm telling you right now, and Jess can speak to this, there is not a judge out there right now in this day and age that isn't awarding double every single time. You will be paying double plus court costs, plus attorney's fees if they have one. If you do not do this within 30 days, you can come to us. You can ask us to defend the case. We're not going to win. The judges are, they don't care right now. 30 days. Your window starts as soon as you get those keys. All right. The check actually has to be sent within 30 days, not just the letter. No. Yes. If they're not getting the security deposit back, the letter has to be within 30 days. If they're getting the security, any portion of their security deposit back, the check has to be mailed within 30 days. You can't on the 29th day say, we did an inspection of your unit. We have 1,000 in security. You have 200 in damages. You'll be getting a check back for 800. The $800 has to be with that letter. All right. Is the maximum $50 application fee just for Philly? Yes. Amenity fee is different from administrative fee. Can be. That's what we were saying. Okay. Super important, guys. I can't tell you how many security deposit cases we're getting over the last year or so. Get them checks in the mail within 30 days.
It just needs to be mailed. It does not have to be received within the 30 days. So send it certified mail so you have a record of when you mailed it.
Or at least the
proof of mailing.
Yeah, thank you. I call it a bump because back in the day, you used to go to the post office and get the little white paper bump. I don't know if you still do that. I think it's all online now, but some kind of proof from the post office saying that you sent it. FedEx, whatever you do, get the date.
Proof.
Yeah, the proof. All right.
Right. That's good.
Security deposit's good. Let me make sure Jess doesn't have anything else. Or Jess, you can jump on here. Do you have anything else, Jess?
All good.
Okay. That's for Jersey too, guys, those security deposit letters. I know we had some Jersey questions on here. What if we don't use checks for security deposits? It's paid through a system that does direct deposits.
Yeah, that's fine. Direct deposit into their account's good too.
Yeah, 30 days.
As long as I get the money, it's not a problem.
Is the email to them good enough? Well, it has to go into their account on those before those 30 days if that's what you're doing. Cool. Yeah. Okay. Awesome. All right. Lexi, you want to take it away? Bankruptcy time, guys. Oh, does the disposition letter need, hold on one second, Lex, need to be mailed or it's emailed? Okay. Here's the problem. The landlord tenant code, despite the fact that Paul has been trying with all his might, has not been updated since the 50s. And so there's nothing in the landlord tenant code that states you can email it.
They didn't have email when it was written.
Now, we can make the argument in court if over the normal course of business, you and the tenant regularly emailed each other, that, that was your course of business. But I would much rather you do both. Email it and mail it and take a picture of the postmark, especially in Philadelphia.
Yeah.
Hey,
So when
public
some
service announcement on New Jersey. My ears perked up when I heard the email question. I know no one asked, but in case anybody's wondering, absolutely not. In New Jersey, it's got to be hand delivered or it's got to be sent certified or registered mail with return receipt. Thank you.
Thanks, Matt. I love how Matt just was like a floating head there for a minute as he popped in and popped back out. Good. All right, now it's your turn, Lexi.
It didn't take nearly as long as I thought you were going to. And then when I saw all of the people on here, I got considerably more nervous. No, I'm just kidding. So
I'm
worst
here, Lex.
word-
I can help.
no, I got you. I think the worst word for everybody at this stage of the game, since I've been here for 2 years now, as of last week, is bankruptcy. The best way I can describe it for you guys is that we're just going to run it from kind of the top down, and I'll answer questions exactly the same way that Janelle and Paul did. For purposes of landlord-tenant law, you guys are going to see one of two types of bankruptcies. It's either going to be a Chapter 7, which is considered a total liquidation of everything, and generally the tenants have to fall under a certain income-based criteria. Sorry, I have a really bad cold, so if I sound terrible, that's for too. In order to be able to do so. More often than not, we're seeing everybody file a Chapter 13, which is just a redistribution of debts. 9 times out of 10, when a tenant files a Chapter 13, it is their intent to stay in the unit. I would say 9 times out of 10, when people file a Chapter 7, it is their intent to stay in the unit, but it's much easier to get them out under those situations than it is under a 13. So what does this mean for you guys? When you receive notice of a bankruptcy, whether it be a 7 or a 13, and you contact me or anybody in my office, we basically start by talking to the attorney for the debtor tenant. If I say debtor, I mean tenant. I have a relatively good relationship with all of these attorneys at this rate, and they can tell me what their debtor, the tenant, intends to do. They're either going to stay, they either want to stay or they're going to move out. Either they have to, what it's called is assume the lease, meaning pay everything in full with a 7, or reject it and move out. For Chapter 7s, under the Bankruptcy Code, which is federal law, which is why when I basically do anything, it comes under federal law. Federal law trumps state law. We have to start there. Under the Bankruptcy Code, a debtor, or really the debtor's trustee, has 60 days to assume or reject a lease. Now, I try to get ahead of that to find out what they want to do. And every single time I get we don't know yet, we don't know yet. When that 60 days comes, we have options to basically force their hand. I try to force their hand a little bit before that, but they do, under code, have 60 days. For a Chapter 13, it's different because those Chapter 13s they create a repayment plan of their debts. These repayment plans are between 3 to 5 years, and depending on if something comes up in the woodwork, it could go even longer than that. So when these situations, a 13 comes up, and say this Sally tenant, as Matt always says, owes $10,000 of what's called pre-petition rent, meaning they had a balance prior to you finding out that they filed for bankruptcy. We then, as counsel, or you guys, file what's called a proof of claim, which is essentially, dear trustee, this tenant owes us, as the landlord, $10,000. This needs to be paid back to us through the Chapter 13 plan, which will be monies paid to the trustee to be distributed accordingly. That's all but at a minimum, what everybody needs to know, and I will back up a second. Once we receive notice of a bankruptcy, everything that is pertaining to evictions or collections has to cease. Does not matter if it's already in court. It does not matter what, it has to stop. And the reason for that is, again, part of the Bankruptcy Code is that if it doesn't stop, there is liability for landlords, there's liability for creditors under the violations of the automatic stay. And just as a little background, I used to do these before I went to law, or while I was in law school. I actually sued creditors for violations of the automatic stay. It's not, it's certainly not a fun thing to find yourself on the receiving end of. So everything collections wise has to stop. And so so that's when we get to the proof of claim section to at least protect you guys, protect everybody on what is currently owed. Now, that being said, anything after the bankruptcy filing date is not considered protected under the bankruptcy code or under the filing of bankruptcy. Thus, we can actually begin the procedures to get to the eviction point. However, we cannot just file in LT court. We need permission from the bankruptcy court in order to proceed in landlord, tenant court, state court. That is by way of motion for relief. And because there's non-payment of rent, Dana, excellent question. I will give me just 1 second. You know, my train of thought. So for motions for relief, we just have to establish why we deserve relief to be able to evict this person. Non-payment of rent are the biggest ones. Probably 90% of the ones I have are non-payment of post-petition rent. As soon as we write to a bankruptcy court, file a motion that says they haven't paid their post-petition obligations, we generally get relief. Judges in bankruptcy court have been pretty strict about it lately to say, sorry about your luck, here's your relief, and at that point we can file an LT court. Do all category, I'm gonna back up just
Well, hold on, back up a second. Yeah. So yes, all categories, I'll give you a breather there, Lex. All categories of bankruptcy shows up on credit. Yes. I don't know what they mean by does that include conviction? And then collection has to stop. You still permit to send notices and calls, not for pre-petition monies, Dana. No. Once we get that relief from the bankruptcy court from the automatic stay for post-petition monies, then you can go ahead and start making those calls.
Yeah.
Absolutely. That's exactly where I was going with
And,
it.
and Paul wants to jump into it. Hold on 1 second.
Yeah.
Sure, go ahead.
I always wondered for years, like, why is it called a Chapter 7 bankruptcy as opposed to Chapter 13 bankruptcy?
I'm sensing a joke here.
No,
Oh.
this is actual. I wonder about this stuff. And the answer is that if you want to learn about a particular type of bankruptcy, you have to go to Chapter 7 in the United States Code, in the right book. And in there, in Chapter 7, it describes a certain type of bankruptcy that you can file. And guess what? If you go to Chapter 13 in that book, it will explain another type of bankruptcy. So people just say Chapter 13 bankruptcy. It's like, what is that? Okay. It's basically comes from Chapter 13 of the code.
Paul's showing his age because there's not books anymore, guys. They're all online. You have to go to Chapter 13 online.
Absolutely right. And there's a Chapter 11 as well, but we won't talk about that. That's mostly business reorganization. It's a 13, but for businesses. So we never run into them. I'm going to say 12, that, and then it's going to come up.
And Chapter 12 if you're a railroad.
Really? Is that what 12 is? I'm not sure I ever knew that.
Yeah.
The other thing I want to say is, and Lexi did a great job of explaining it, but I just wanted to make sure that everyone understood that the key date in the bankruptcy filing is the date that they actually file the bankruptcy. Because what happens is that all the debt that's owed at that time becomes what Lex explained was pre-petition debt, pre-filing of that petition. Okay. Once you file bankruptcy, you can't keep incurring new debt. That'd be ridiculous. Okay. Okay. So the court says, and the law says that once you file, that's it. That's all that's included in your bankruptcy. Any new debt that you incur, you now have to pay for. Well, the rent is owed monthly. So on the next month, the rent is due. They can't include the future rent in that bankruptcy. So as the rent becomes due, that has to get paid. And what happens is when they don't pay that ongoing rent, because that's not part of the bankruptcy, we can now proceed against them for that ongoing rent. We can't proceed against them for the back rent especially if they filed a Chapter 13, because they're going to come up with a plan to pay that over time. But the current rent that they're not paying, that's what we can go after them for. But because they filed the bankruptcy, as Lexi said, everything is stayed, stopped. You can't go after them. You can't try and collect the money that they owe without first getting relief from the bankruptcy court. So you got to go to the bankruptcy court and say, yo, bankruptcy court, they're not paying the ongoing rent. I need to be able to go to state court and be able to sue them to get my rent money and be able to get them out of the property. You can't go to state court because everything's been stayed. So you first are going to bankruptcy court asking for permission. You get the permission from the bankruptcy court, and then we go and proceed in state court to get them out of the property for that ongoing rent that they haven't paid.
And don't forget, like Lexi said at the beginning of this, and was always my handy dandy tool that I taught us. We do try, because especially in a Chapter 7, they have to reaffirm the lease and pay all the back rent if they want to stay, especially in a Chapter 7. We do try and say, hey, look, idiots, they're not going to be able to pay this $10,000 they owe. When do you want to get out? Let's just do an agreement. We'll give you 30 days. They get out because they're not going to reaffirm this lease. Sometimes they'll be very responsive to Lexi and say, sure, and we'll do an agreement. Other times they'll say, we have 60 days. And then on the 31st day, when they haven't paid their rent for the next month, we file anyway. So
Cheryl's absolutely right. They always tend to kick the can down the road, buy as much time as they can. Like you guys always know, they all try to buy as much time as possible without having to actually do anything. Thus, we have to start putting it into their brains to say, hey, I'm on top of this. Just let them know.
And once they file for that bankruptcy, they can, and this is what Lexi was saying, reject the lease means they can actually get out of the lease agreement. It's a way to end the lease agreement without having to keep paying the ongoing rent. So the money that they owe, if they file a Chapter 7, they can wipe that money out, but they got to leave. Okay? If they don't,
I see a question here. I'm sorry, Paul, I didn't mean to interrupt. I see a question. I think I understand it. So if I'm getting it wrong, just let me know. There's a question that says, what if it was before bankruptcy? Can you amend the complaint to only present month owed? If I don't know if that means that a current filing is still in process. So say this happens to us all the time, that we filed an LT complaint on the 11th hour before the hearing, they file for bankruptcy. Generally speaking, we still can't just amend the complaint for what's owed after the bankruptcy, because you still have to, I know it sounds crazy, but even post-petition rents, so rents ongoing, we still have to get permission from the bankruptcy court to proceed on ongoing rent. They still have protection, even though that money isn't protected, they still have protection from being removed from their property. So we can't just amend those complaints. I've also had people ask me if it would be possible to just adjourn landlord-tenant complaints out. And honestly, it doesn't make sense to continue to do so, especially if they miraculously do keep up with their post-petition obligations. You'll just be kicking that can indefinitely down the road. You could potentially be kicking it down the road for 3 years. And that, I would say, it doesn't happen very often. I'll be honest with you guys. I think I've had, in the 2 years that I've been working here, I've had 2 tenants actually stick to their Chapter 13 plans and everything's been going fine. So I would always advise to not do so.
right,
Meredith's
go
got a
ahead.
great question. Just had one happen. So the Chapter 7 to Chapter 13 is kind of, people do what they call conversions. You can either convert one way or the other. I can't remember off the top of my head, but you generally can't go from a 7 to a 13. You can only go from a 13 to a 7. And once that happens, there's a lot of argument about what's considered post-petition and pre-petition rent at that point. I've had many a conversation with debtors' attorneys who tell me what their argument would be is that as soon as the conversion happens, that's the new date. But I've said, I would make an argument the other way, and they go, that's a valid statement. Let it play out in court. So the 60 days would still come into play for assuming or rejecting the lease. And I would probably play it on two different wavelengths at that point. Make a determination, but then also file the motion for post-petition rent owed back from the original date and kind of put the ball in their court to see how they want to play it. 9 times out of 10, they owe an exorbitant amount of money, and it's never going to be.
And you're doing an agreement to say you're leaving in 30 days.
Exactly right.
Can we still charge lease termination fees if they choose that they want to break their lease? No. Nope. Sorry. That's what a bankruptcy is all about. Wipes out their debt.
100%.
And
And this also brings up a very interesting situation that I've been dealing with, especially in New Jersey, where people have come up for renewals. And not only do we have to fight the renewal waivers of any pre-petition debts under Montgomery Gateway, and then renewals just in general. So it's a case-by-case basis for me when somebody asks me, should I renew a lease? Generally, the answer is no, especially in New Jersey. It doesn't really apply so much in Pennsylvania because we can non-renew people. But again, if we non-renew, we have to be very delicate about it. Cancel the
Your best
LT.
case in Jersey, if you can't remember that, is to do nothing. Don't just let the automatic month-to-month renewal, whatever, kick in.
Yes.
Because at least we can do something about it afterwards.
yeah, and
Canceling
really,
the LT and refiling. Yes. We do this frequently.
That's what we do. Yeah.
We cannot refile until after we receive the order from the bankruptcy court that says you have received relief from the automatic stay. But yes, they can be canceled and refiled. There is, this is just, I guess.
Don't get too into the weeds.
Maybe, okay.
Sorry.
Yes, we can.
yeah, I was going to say, yeah.
Yeah.
So
It becomes a little, that's something
Yeah.
for an individual case-by-case
Here's-
basis we can talk about when it comes to refiling.
Here's the bottom line of what everyone really needs to know. When someone files a bankruptcy, you want to get that to us immediately. The sooner you get it to us, the better off we are.
Yeah.
We can get on it right away. As Lexi said, she gets in touch with the other attorney. She tries to figure out exactly what's going on so that we can get you possession as quickly as possible. And if we need to file a motion for relief, you're going to want us to do that as soon as possible to get the ball rolling. Until we file that motion for relief and get the relief, we can't go in the state court and start the eviction. So the bottom line is, someone files for bankruptcy, contact us right away. And if you forget everything that happened on this call and everything we talked about, we'll walk you through it all again so that you know exactly what's going on. But make sure you get it over to us so we can get started on it right away and help you.
All right. Two of these questions. No, you don't have to wait 60 days. You have to wait 30 days so they don't pay the next month's rent. Number two, if they file the lease termination, they file bankruptcy, the lease termination fees for the lease affected in the bankruptcy cannot have lease. You can't charge a lease termination fee. The idea behind a bankruptcy is it wipes out their debt and they can terminate their lease. You can't charge a termination fee because it's not post-petition. It's tied to when they file the bankruptcy. It ends the lease because they're ending their debt. So you got to get that out of your head. The lease termination fee is going out the window if they file for bankruptcy. If they assume the lease, they owe all the rent. If they reject it, they have to move out. Yep, you got it. 100%. That's about as succinctly as we can say it. Thank you, Sean. Is there a formal way to find out if a tenant files for bankruptcy? There's dockets. So we can search the dockets. If you think they may have filed a bankruptcy, but you weren't served with it, then we can check the docket. Just let us know. But here's the reality of it. We're going to know because the reason they're filing for a bankruptcy is because they want to stop the eviction. So as soon as they file, they're going to notify you. They're going to notify us. It's very rare we don't find out very quickly.
I can say there have been a few surprises, and the surprises have simply been because the tenant themselves did not tell their bankruptcy attorney that they owed rent, which is very odd, but not uncommon.
Sure.
But I generally a lot of the really good bankruptcy attorneys, especially in New Jersey, where the majority of our cases are right now, they know us, they know our firm, and they send notices directly to us upon filing. I got 4 on my desk this morning, so they know. Most of them know who's involved.
I will say this: there are times where a tenant is current on their rent and they file for bankruptcy because they owe something somewhere else, whether it be credit card debt, car payments, whatever the case may be.
Medical bills.
Yeah.
Medical bills.
So in that case, the only way we're going to need to proceed in court is if they don't keep paying their post-petition monies. There is no pre-petition debt. We're not a creditor at that point because they don't owe anything. If they stop paying their post-petition monies, at that point, we need to then do what Lexi said and get relief from the court to be able to proceed at the state court level.
Best way I can say, I'm just looking at a couple of the questions. So for the time, is there a time frame to file for relief? That kind of gets a little bit in the weeds too. You basically, I guess the best way I can describe it for everybody involved is everybody is programmed to say, okay, rent is due, send it over to Diane, send it through the portal to get the LT started. If the tenant is in an active bankruptcy, think that same thing, but instead of thinking send it to LT, send it to me, because yes, you can immediately make moves on it. The moves just have to be in a different court. There's no really timeline essentially to wait for it. If rent is owed, I can be contacted immediately and say, Lex, rent is owed. We need to file for relief. What we can't do is file an LT court without relief. So to kind of go, yes, you can cancel, but you cannot, if you cannot file a new LT case until you get relief from the bankruptcy court. That is a hard rule.
And filing for relief generally won't happen until the next month's rent is due, just because we need that argument, as Lex said, is the reason we need relief. But again, as she said, she starts a lot of other things prior to doing that. Contacting the attorney, finding out if they're going to reaffirm their lease. If it's a Chapter 13, we're filing that proof of claim to preserve how much money we are owed. You're owed. You get the point. So the minute you find out there's a bankruptcy, you want to get in touch with Lex. Okay. If you cancel LT before the end of the month, next month you can file as soon as rent's owed, not until we file for relief from the bankruptcy court. That's the name of the game.
That's probably the biggest takeaway I want from this, is that when in doubt, we need relief from the bankruptcy court. When in doubt, we need relief. When in doubt, we need relief.
We only receive relief on future rent, not the balance owed. Yes and no. So
yes and no.
So yes, under normal circumstances, but we can also get relief if they're paying post-petition, but they reaffirm the lease and don't pay the back rent, then we can then proceed for a motion for relief as well. If they don't stick to their plan, there's things we can do. So not necessarily, but 9 times out of 10, we're seeking for relief from the automatic stay because they didn't pay their post-petition monies.
Exactly right. I tell people a lot in these situations that, again, getting a little bit in the weeds, but when it comes to bankruptcy tenants, it needs to be made violently clear that you either want possession of the unit or you want your money. You're really not going to see both. And that's kind of a big, I would say, roadblock for a lot of property managers, is that they're like, well, they owe us this money. Yeah, but it's being held under lock and key. What matters more? Is it getting the unit back to get it into somebody who can make up that money that you're owed? Or do you want to wait?
Yeah, do you want your money and they're going to stay? That's where you're at.
Yeah.
And getting your money is going to be paid through a plan of either 3 to 5 years, somewhere around
Exactly
there.
right.
And
exactly
so
right. And at the very least, you may not even see half of it.
You get 160 of it every month.
Exactly right, Paul. And a lot of the times too, if the bankruptcy attorney, the debtor's attorney is smart, be that, you take that with where you will, they will then, as soon as we get relief from them, basically saying you're not paying your ongoing rent, a lot of the times bankruptcy attorneys will go, hey, we don't care that you get relief. Get tenant, you got to leave. If you leave, we'll remove your claim from the plan because you guys have the property back anyway. Yeah. But that's for another.
And you're not going to see a penny.
Yeah, not going to see a penny after that point.
But at that point, we can get them out. And listen,
right.
How many times we file evictions, we get somebody locked down, you don't see a penny anyway. All it's doing is adding a couple more months, which absolutely sucks. But we do. That's why we say get it in our hands as fast as you can, because it does take time, and time is money, and you're already losing money. So we need to, as quickly as possible, start that process. Okay. If tenant is current on rent, files 7 or 13, we only need to come. Yeah. Yes. Correct. If they become delinquent, 100%. If they're paid up and they're current and they're going to keep going, we don't need to hear from you unless they aren't current anymore. This is a lot. Yes, we know, Meredith. That's why we're doing this. And we're here. And listen, we wanted to give you a basic overview because Lexi gets a lot of questions and we want you to understand what that process looked like from start to finish. We don't expect for you to memorize it and remember it from now to the end of eternity because we get it. We do this every single day. All right. I bug her the most. Yeah, we all have our people that bug us the most. We get it. But at least now you've got kind of a general overview and an understanding of how that process works. And just know you're in good hands with Lex. And we'll keep at it. We understand time is money.
And
Right.
I would be remiss if I didn't say that these are as incredibly frustrating to me as they are to you all as well, because I
Yeah.
know how much time it takes and I know how much time goes by that somehow, some way, it always feels like they're getting more time to do something. So know that I am just as frustrated half the time when it does feel like they always get a second chance. They always get a second chance because this kind
Oh,
of
there is
leads to
one
people
point
getting.
that is actually going to help. If we already have a judgment against a tenant and the lockout hasn't happened yet, and they file the bankruptcy. Thanks to this gentleman back here in 2005. Oh, I'm really making you sound old now. He was instrumental in helping to rewrite the bankruptcy code. It's kind of funny. It was the year I started at the firm and it happened. In stating that once we get a judgment, the bankruptcy does not stop the lockout. Okay. We can perceive the lockout. A lot of judges don't understand this. We actually have a letter we have ready to go to hand to judges to show them the law. But there is one exception and one caveat to this in the bankruptcy code. Is that what you're about to say, Lex?
Yeah, yeah.
They can pay 1 month's rent into escrow with the bankruptcy court and buy themselves 30 days on that lockout. I will say it might have changed. Back when I used to do all the bankruptcies, 7 out of 10 bankruptcy attorneys didn't even know that existed. I'm guessing that those numbers have changed nowadays. And a lot more of the bankruptcy attorneys know they existed. I'm dating myself, but back when I did the bankruptcies, it was a relatively new thing. So a lot of them didn't know.
Yes, so way back when, what would happen was the tenants would wait until the day of the lockout and file the bankruptcy on that day. And that was one of the busiest days in bankruptcy courts when lockouts were taking place. So that's when the law changed to basically say that no, if the judgment's already been obtained, the tenant isn't entitled to a motion for relief, or you don't have to file the motion for relief. You can go ahead and proceed, except in that one instance. Right?
That was the literal caveat that I was getting to. I've had quite a few of them lately.
Yeah, so the debtor's attorneys realize that now, so now they file the bankruptcy prior to you actually going to court and getting the judgment.
Look, someone says they remember the change too, so they're old too. See, we're not the only old heads here.
Let me just pick up on that for just a second for Janelle's point. They buy themselves 30
Okay.
days to pay the entire judgment in full.
Yes.
And they have to certify that with the bankruptcy court as well. If they don't, we pick right back up.
Guess
So
what?
just-
I've never once in all the years I've been here, and Lexi may have seen it. I never saw it. I've never seen anybody do it.
I had one.
They paid the whole judgment? Oh, I've seen them file the certification and pay the 1 month, but I've never seen anybody pay the whole judgment. So Lex has one. She's got one up.
I have one. I have one, and I actually just have another right now who she told her bankruptcy attorney that she did. Come to find out, she was $7,500 short. So I have to fight with that guy.
Shocker. All right.
I've only had one, but other than that,
I think we have bent all of your ears long enough. Jess, was there anything else you wanted me to touch on quick before we end this?
Nope, covered all.
You're good. I know we have like 10 people in one room trying to keep this open for a bunch, so it's a little quiet. If you have follow-up questions, just reach out to anybody here, or if you don't know who to reach out to, just send it over to Danielle and she'll get it into the right hands. Because I know that was a lot of information that we all threw at you at once in 1 hour's time. So, all right. And we have this recorded, so if there's somebody in your office that missed it, we can get it into your hands. All right. All right. Thanks,
Good.
everybody.